Welcome back to Counting to Five, a podcast about the United States Supreme Court. In this episode, I talk with Jessica Ring Amunson, the co-chair of Jenner & Block's Appellate and Supreme Court practice, who earlier this term argued at the Supreme Court on behalf of petitioner Rodney Class in the case Class v. United States. This interview was recorded in the fall prior to the oral argument. Please keep listening after the interview for information about Counting to Five's weekly YouTube live streams covering the latest developments at the Supreme Court. Now, on to the interview. I'm speaking today with Jessica Ring Amunson, the co-chair of the Appellate and Supreme Court practice at Jenner & Block, who represents Rodney Class, the petitioner in Class v. United States, a case currently pending before the Supreme Court. So maybe we could start by, you could just tell us, who is Rodney Class and how did he become involved in the criminal justice system?
Rodney Class is a retired veteran from North Carolina who was visiting the United States Capitol and parked his car in a parking lot on the 200 block of Maryland Avenue, which is right by the U.S. Botanic Garden, and then proceeded to the Capitol. He had within his locked car firearms that were legally registered, and when he returned to his car, there was a Capitol police officer there who asked to search the car, and he was later charged with violation of a federal statute that prohibits having weapons readily accessible on Capitol grounds.
And I understand he had represented himself pro se, and he raised some constitutional arguments against the charges. Can you talk briefly about what his constitutional claims were?
Sure. So in the district court, he raised challenges, a Second Amendment challenge, saying that it infringed his Second Amendment rights not to be able to have his legally owned and permitted guns in his locked vehicle. And he also raised a due process notice challenge in that there was no way to know that where he actually parked was considered Capitol grounds where this statute applied.
Right, and those arguments, at least at the trial court, didn't go anywhere.
That's right, yeah. The trial court did order the government to respond to his Second Amendment argument, but eventually decided against him. So he had moved to dismiss the indictment on various grounds, and the trial court did not dismiss the indictment.
So eventually he ends up pleading guilty. Can you talk a little bit about that and about the plea that he entered into?
Sure. So he was set to go to trial and then informed the court that he would not be appearing for trial. He was then arrested in North Carolina and brought to D.C. and incarcerated. And he, while incarcerated, eventually pled guilty while awaiting a new trial date to be set. And his plea agreement, it waived certain of his trial rights. It waived his right to bring a collateral attack to his conviction, and it waived his right to appeal his sentence, but it did not waive in any way his right to directly appeal his conviction, nor does it contain any waiver of his right to assert any constitutional challenge to the statute that he was pleading guilty to.
As I understand it, the government doesn't dispute that there was no express waiver of the right to directly appeal his conviction. Is that right?
That's correct.
So moving on in Mr. Class's story, after he pleads guilty, he tries to appeal to the D.C. Circuit on his constitutional arguments. Can you explain what happened there?
Sure. So he appealed almost immediately after pleading guilty, and the government never moved to dismiss his appeal. It remained pending. And approximately, I believe it was about a year after he had filed his notice of appeal, one of my partners got a call from the clerk of the D.C. Circuit. My firm, Jenner & Block, has a very strong pro bono commitment, and we have relationships with both the D.C. Circuit and the Seventh Circuit, whereupon we are often appointed in the Seventh Circuit to represent parties directly, and in the D.C. Circuit, the way the D.C. Circuit does it is they appoint people as amicus to a party to brief issues that the court wants to have addressed. Mr. Class was representing himself pro se in the D.C. Circuit, and the circuit reached out and asked us if we would take on the appeal. And that pro bono program tends to be a way that many associates get their first opportunity to argue an appeal. And in this case, an associate named Trent McCotter approached me and asked if I would supervise him in doing this appeal as amicus to Mr. Class. So Trent briefed and argued the appeal in the D.C. Circuit.
At that point, on that initial brief, that was on these constitutional claims, the Second Amendment claim, the due process claim, but then things changed after that as this guilty plea issue came up. Is that right?
That's right, yes. When the D.C. Circuit appoints you, they sometimes tell you exactly the issues that they want briefed. In this case, they did not. And so we assumed that probably the reason we had been asked to brief the issues was because there were some novel Second Amendment issues that the case raised. And so we fully briefed the Second Amendment issues, we fully briefed the due process issues, and we also included some argument about the fact that Mr. Class's appeal was not precluded by his guilty plea. But then when we received the government's response brief, their brief was primarily based on the argument that the court should not reach the merits of any of Mr. Class's constitutional claims because the entire appeal was precluded by the simple fact that he had pled guilty.
And ultimately, the D.C. Circuit agreed with the government on that.
That's right, yes. So we had argument in the D.C. Circuit. Trent did the argument in the D.C. Circuit, and the argument focused largely on something that's called the Blackledge-Mena Doctrine, which comes from two Supreme Court cases called Blackledge and Mena, which held that you are, in fact, entitled to raise certain claims after pleading guilty. And so the argument focused on that as well as on Mr. Class's plea agreement itself and the fact that he had not expressly waived his right to directly appeal his conviction. And as you said, the D.C. Circuit eventually issued just a short per curiam opinion essentially saying that under D.C. Circuit precedent, they had interpreted the Blackledge-Mena Doctrine not to apply to constitutional challenges to the statute of conviction.
As I understand it, there's a circuit split on that issue?
That's right. So we then filed a petition for cert, pointing out that there was, in fact, a pretty deep and entrenched circuit split on the issue, with some circuits holding that a constitutional challenge to the statute of conviction was not precluded by a guilty plea under Blackledge and Mena. Some circuits holding that it was, in fact, precluded, as the D.C. Circuit held, and then other circuits having kind of an in-between approach of holding that facial challenges were permitted but not as applied challenges.
So the Supreme Court ended up granting your cert petition.
It did.
And you're the counsel of record on the briefs. Are you also going to be the one arguing the case in October?
I am. So Trent, who handled the case below, in between the time that we filed the petition and the time the petition was granted, Trent had applied actually for a position as an assistant United States attorney in the Eastern District of Virginia, and he got that position. So I was left with the case and will be arguing it before the Supreme Court. And unfortunately, I can't rely on Trent's assistance at all since he now works for the other side. So.
Well, it's a lucky development for you, getting a Supreme Court argument out of it.
Sure, yeah. I mean, I'm glad that we were able to raise this issue for our client.
I guess let's try and dig in a little to the legal issues that the court's going to be deciding. You mentioned before the Blackledge-Mena Doctrine, and as you said, there was a pair of cases from the 1970s, Blackledge v. Perry and Mena v. United States. Could you just tell us a little bit about each of those cases?
Sure. So Blackledge was a case about essentially prosecutorial vindictiveness. So a case where defendant was charged with certain crimes, and then when it was in North Carolina, back when North Carolina allowed a trial de novo after you'd been convicted of a misdemeanor. So essentially what happened was the prosecution came back and charged the defendant with a felony, and the defendant pled guilty to that felony. And then on appeal, the government argued in part that the appeal was precluded because he had pled guilty. And the court held that, in fact, it was not precluded because essentially the prosecutorial vindictiveness claim was a claim that would have prevented the defendant from being tried or convicted at all. So that was the Blackledge case. And then the Mena case was somewhat similar. It was actually a double jeopardy case. And again, the court held that the defendant was not precluded from raising on appeal his double jeopardy challenge simply because he had pled guilty, because in fact what was precluded would be constitutional challenges that would be inconsistent with the plea of guilty. So, for example, raising a Fourth Amendment challenge, the court sort of held that you could be precluded from raising a Fourth Amendment challenge because your plea of guilty was inconsistent with later raising that claim, because you're essentially, when you're pleading guilty, admitting to the facts underlying your guilt and admitting that the government has sufficient evidence to convict you. But a double jeopardy claim would have precluded the prosecution from taking place at all. And so the underlying issue in this case is whether a constitutional challenge to the statute of conviction falls within that same sort of reasoning of Blackledge and Mena, that you should not be precluded from raising a constitutional challenge that would have prevented you from being tried or convicted at all.
Right. And so the government responds, they say basically those cases, they really only stand for the idea that you're allowed to appeal on grounds that would have prevented the government from bringing the case at all. And they say that a conviction on an unconstitutional statute doesn't fit that category. Why, in your view, is that wrong? Are they wrong?
Yes. So the government tries to draw a distinction and say that those cases are really about the indictment and whether you could have been sort of hailed into court at all. And really what we say is our case is just exactly the same. So, it's literally almost the same as the Mena case, in that the defendants both attempted to dismiss their indictments. They failed at dismissing their indictment. They appealed, and it wasn't until the appeal and eventual, for Mena, trip to the Supreme Court that the court validated his constitutional argument and held that it was not actually precluded by his guilty plea. So really what we say is that if Mr. Class is correct that the Second Amendment invalidates the statute under which he was convicted, that it's exactly the same as the Blackledge and Mena doctrine, that it would have precluded any prosecution or conviction from taking place at all.
So there's another issue that's in play, and that's Rule 11A2 of the Federal Rules of Criminal Procedure. For the benefit of the listeners, the federal rules, they basically spell out how a case plays out in the court system. It talks about things like what papers need to be filed and when, what kind of hearings need to be held, when to file certain types of motions, things like that. And the argument here that the government is making is about Rule 11, which is about pleas, and specifically Rule 11A2, which is about conditional pleas. And I'll just read it's not very long. I'll read the language here. With the consent of the court and the government, a defendant may enter a conditional plea of guilty or nolo contendere, reserving in writing the right to have an appellate court review an adverse determination of a specified pretrial motion. A defendant who prevails on appeal may then withdraw the plea. So here the government basically says, look, Rule 11A2 says how this is supposed to work. If you want to reserve the right to appeal, you need to enter a conditional plea. Class didn't do that here, so he's out of luck. That's basically what they're saying, right?
That's right, yep.
So from your view, what's wrong with that argument?
So one of the main things that's wrong with that argument is it sort of ignores what else the advisory committee said when it was drafting that rule and what the state of the law was at the time that rule was drafted in 1983. So as you said, when Rule 11 came about, it was expressly authorizing the conditional plea procedure, which had been taking place in some courts, but there was some doubt as to whether it was, in fact, a valid process, and so Rule 11A2 was added to say that, yes, conditional pleas are allowed. But the advisory committee in the notes to Rule 11, when it added it, specifically called out the Blackledge and Mena doctrine and said that the conditional plea procedures prescribed by the rule were to have no application to such situations and should not be interpreted as either broadening or narrowing the Blackledge-Mena doctrine or as establishing procedures for its application. So the advisory committee was pretty clear that the conditional plea procedure set out in Rule 11A2 was not meant to affect cases that fall within the Blackledge-Mena exception.
I think at this point, I think that gives us a pretty good overview of the major, legal arguments that are going to be in front of the court. And I wondered, I'd like to step back a little and try and situate this case within a broader context, which is the role that plea bargains play in the criminal justice system. And something some people might wonder here is if Mr. Class just wanted to challenge this and keep raising his constitutional claims, then why wouldn't he just plead not guilty and keep pressing forward? So I guess the question is, why does someone, not just Mr. Class but others in a similar position who have claims that they want to keep pursuing, why would they plead guilty?
Right. So the vast majority of criminal cases in the system today end up in guilty pleas. It's, I think, 96 or even 98% of cases end up in a guilty plea. And that is largely because the defendants can obtain typically a more advantageous sentence by pleading guilty as opposed to going to trial. It also conserves the resources of the prosecutor and the court. And there's, tremendous pressure as well on defendants to plead guilty because they essentially have hanging over their heads the idea of a much longer sentence if they go to trial.
From the government's perspective, I would imagine they would say that part of the benefit to the government, when the government agrees to some sort of plea deal, part of the benefit that they're getting is avoiding drawn out and costly appeals. And so that part of the bargain from their perspective would be trying to cut off precisely what's the type of appeal that's at issue here.
Right, and I think we have a pretty simple answer to that, which is that if the government wants that to be part of the bargain, then the government needs to expressly include that as part of the bargain. And here the government did not do that. So the government can, in fact, as part of a plea agreement, and typically does as part of a plea agreement, ask the defendant to waive their right to directly appeal their conviction and or, in some cases, to waive constitutional challenge to a statute, but that is not what happened in Mr. Class's case.
That's interesting because one of the things I was going to ask you was how much does this case just turn on the specific language of this particular plea agreement? And the question is, going forward, if you win here, if Mr. Class wins at the Supreme Court, couldn't the government going forward effectively just avoid this problem by including language in its standard plea agreements, waiving that right to appeal?
So it could, and, as I said, it often does include as part of its plea agreements the right to, or the request that the defendant waive their right to directly appeal their conviction. I will say the government also maintains that it has the right to ask a defendant to waive their right to effective assistance of counsel, but they typically do not do that in a plea agreement. And it seems to me that this is the same or a similar type of right that perhaps as a matter of policy the government should not be asking defendants to waive, which is to raise a constitutional challenge to the statute under which they're convicted. And, we've raised in our brief also sort of the analogy to on habeas proceedings, so post-conviction collateral attacks on a sentence. There is a doctrine called the Retroactivity Doctrine, and there the court sort of treats especially the idea of a defendant who's been convicted under a statute that is later found to be unconstitutional. And it seems to us that the court should recognize that this is also sort of a special type of right in this context as well.
Do you have any insight in why the government does include that kind of waiver language in some plea agreements and not others?
I don't. I think, as I understand it, the plea agreements are often pretty standard within a U.S. Attorney's office, and some may include it, some may not. I think it's usually pretty typical to include in a plea agreement that the defendant is going to waive their right to appeal their conviction as well as their sentence.
Coming back to Mr. Class again, if he wins here, that doesn't mean he's home free. It basically just means he's back to the D.C. Circuit, but able this time to push forward with his Second Amendment and due process arguments in the appellate court there. That's
right. Yep.
So this is, I guess, a type of case that's not uncommon at the Supreme Court, where really there's a lot of fighting over a preliminary issue just in order to get to the main battle that the party really wants to fight.
Exactly. Yeah, Mr. Class was important to Mr. Class, as evidenced by the fact that he filed his notice of appeal almost immediately after pleading guilty, that he be given the opportunity to raise his Second Amendment and due process challenges, and he intends to hopefully do that on remand to the D.C. Circuit.
Well, I think that pretty much covers the questions I had. Before we finish, do you have any final thoughts about the case that you'd like to share with the listeners?
I think it's a really interesting case. It seems to me like the kind of criminal procedure case when I first heard it that I thought, hasn't this already been answered? So it's like many other Supreme Court cases where it's an interesting question, and when I tell people what the question presented is, whether a guilty plea inherently waives a constitutional challenge to the statute under which you're convicted, people seem to have sort of strong reactions one way or the other immediately, whether they're lawyers or non-lawyers. So there are many people who say, of course not. All you're doing is pleading guilty to the facts, to say, yes, I did that, but you're not necessarily conceding that Congress was constitutionally authorized to pass the law. You're just saying you did what the law prohibits. And then other people have a very opposite and immediate reaction, which is, of course, once you plead guilty, that's game over and you should not be permitted to raise anything more in court. So I think it's a case that has some broad appeal beyond just the lawyer set.
It does seem surprising that this is still an open question, that the court hasn't kind of squarely answered it. It's not a new problem.
Yeah, no, and it divided a bunch of circuits, so it will be great to have the court weigh in and resolve it.
So your law firm, Jenner & Block, is online at jenner.com, and listeners can find your bio on there. Is there anywhere else you'd like to direct people if they want to find out more either about you or about this case?
No, the briefs are available both through the ABA website and on the SCOTUS blog website that keeps track of all the Supreme Court proceedings. And so all the briefs are there, and the argument is on October 4th.
I know I'll be looking forward to listening to the argument. And I just want to thank you again for taking the time to talk with me today.
Thanks so much to you and your listeners. This is terrific.
And that brings us to the end of episode 21. If you enjoyed listening to this discussion of Class v. United States, the oral argument audio is available at the Supreme Court's website and is linked in the show notes. The argument is worth listening to in full, but I would like to play one short clip from the government's argument, which presents an interesting statistic about guilty pleas that I wasn't aware of at the time of the interview.
I wouldn't want to sit down without informing the court that there 25% of the pleas in the federal system don't even involve plea agreements. They're open pleas. And when a defendant enters a plea without an agreement, and the district court and the government have every expectation that that ends the case, the defendant should not be able silently to reserve a challenge to the substance of the conviction that the defendant assented to the court entering.
I'm sorry, what do you mean an open plea?
We call them open pleas. Is just a term for a plea without a plea agreement. So the defendant simply decides to plead guilty himself, so that without a plea agreement, he gets acceptance of responsibility points for that.
If you're interested in hearing more, be sure to listen to the full oral argument audio. For the past several weeks, Counting to 5 has been hosting a weekly YouTube live stream discussing the latest developments at the court. At least for the time being, these are being broadcast live on Thursday evenings at 9 p.m. Eastern Time, but you can check the Counting to 5 YouTube channel to find the next scheduled live stream. If you join us during the broadcast, you can ask your own questions in the live chat, and I'll do my best to answer them live on the air. Links to resources related to this episode can be found in the show notes at countingto5.com. That's TO and the number 5. You can leave comments and questions on the show notes post at countingto5.com, on the Counting to 5 Facebook page or YouTube channel, tweet at countingto5, or send an email to mike@countingto5.com. You can call and leave questions and comments on the Counting to 5 voicemail line at 774-226-8685. That's 774-2-COUNT-5. Your feedback helps us bring you a better podcast. If you aren't already subscribing to Counting to 5, please subscribe now at iTunes, Stitcher, or wherever you find podcasts. Thank you for listening. This has been Counting to 5.